Can this new bill clean the Indian politics? Can there be automatic removal of ministers? And why India needs removal of arrested ministers? In our country, 46% of our MP have criminal charges against them. And this is where criminalization of politics becomes a serious threat to our democracy. And to address this, the government is bringing in 130th Constitutional Amendment Bill of 2025, which ensures that not just ministers and chief ministers, but also prime minister is brought under the ambit where their removal will be assured, the removal will be automatic if they are arrested. Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh and today we are going to understand the intricacies related to 130th Constitutional Amendment Bill of 2025, what it will change in terms of criminalization of politics that we are seeing high time in our country, or it will be another political weapon or risk. So let us start with understanding this proposed bill that is coming in through. So this bill has been proposed by Union Home Minister Amit Shah, and basically the aim of this particular bill is to provide a proper legal framework. तो यहाँ पे ये जो बिल है इसका पूरा एम ही यही है कि एक प्रॉपर लीगल फ्रेमवर्क आए. लीगल फ्रेमवर्क किस चीज़ के लिए? ताकि यहाँ पे चीफ मिनिस्टर्स, प्राइम मिनिस्टर और भी जो बाकी मिनिस्टर्स हैं वो अगर वो अरेस्ट होते हैं तो उनका रिमूवल जो है वो इंश्योर हो सके. इन शॉर्ट, दिस डायरेक्टली एम्स एट द लीगल फ्रेमवर्क in the case of PM, Chief Minister or ministers and their removal if they are arrested. The main core provision of this particular bill is the fact that a minister, if arrested or detained for 30 consecutive days, and this is in association with charges which are punishable for 5 or more than 5 years of imprisonment. In this scenario, on the 31st day itself, there will be automatic removal of that concerned particular minister. That is the main core provision that, okay, if you have imprisonment charges of more than 5 years or equivalent to 5 years and you have been arrested or detained for 30 days, then on 31st day, that means being a minister, chief minister or prime minister, there will be automatic removal. There is provision of reappointment in case you find that imprisonment charges which are being levied, you're not convicted. In that scenario, once you are released, there is the provision for reappointment which has been given in the bill itself. Now, when we look at this particular main provision, it becomes important for us to understand that why are we being so harsh in terms of ministers who are coming from such background. I'll tell you the reason behind it as I started with it, that criminalization of politics is a huge threat to our democracy. And in this scenario, please look at this given diagram. If you see criminals, these criminals will not just use money but also use their muscle power against other politicians and win elections and become politicians. In this scenario, we have a very simple data where a criminal background politician is 3 times more likely to win than a person with clean record. A candidate with clean record and a candidate with criminal record, given our data we have seen, it is 3 times likely that he might become a politician or a lawmaker, MLA, MP in our country. Now, such people will automatically give support and patronage to criminals, which will lead to creation of more criminals created, more criminals to become our lawmakers, and this vicious cycle goes on. Who will be majorly threatened here? It would be the public. Public's rights would be taken away either through muscle power or lawmaking in all sort forms, and that is the main threat to democracy. Another reason this law is very much needed, or such addressal to criminalization of politics is very much needed, is the fact as of now, if we look at constitution, there are no explicit provision. That means यहाँ पे कोई direct provisions है ही नहीं ऐसी situation के लिए. तो यहाँ पर aim क्या है? किसी भी तरीके के जो gaps हैं, चाहे वो आर्टिकल 75 में हो, चाहे वो आर्टिकल 164 में हो फॉर स्टेट्स, या यूनियन टेरिटरीज 239 AA दिल्ली के लिए है, इन सब में जो भी गैप्स हैं विद स्पेशल रेफरेंस टू क्रिमिनलाइजेशन ऑफ पॉलिटिक्स, उनको हम प्लग करें और इस सिचुएशन को एड्रेस करें. नाउ लेट अस अंडरस्टैंड द main provisions, be it constitutional and legal, associated with this bill. So as I said, the main core provision of this bill is the removal of ministers if they have been imprisoned. That means they have been arrested or detained for more than 30 days and the imprisonment charges are for more than or equal to 5 years. And for this particular provision, they are going to revise Constitution's 3 articles. There will be key amendments in 3 articles. Article 75, where there will be a removal process for central ministers, including Prime Minister. Then Article 164 for state ministers, where there will be extension of the removal process to Chief Minister and state cabinets. And then we have Article 239AA, that is for Delhi government, specific applicability where union territory comes with an assembly. Now, this is the main amendment that we are going to see in terms of constitution, and there has been a clear legal rationale behind it as well, because as of now, if you look, the disqualification of the members or ministers occurs only after they have been convicted of that crime, and that happens through Representation of People Act 1959. So again, no provision is coming from constitution. It was not constitutionally backed. If this bill becomes an act, then it will be constitutionally provided. And this bill is trying to fulfill that gap that is coming through, that it will enable removal at the very stage of the arrest and detention, not at the later stage when the person is convicted. Now, this whole scenario basically also points to the other side of the coin, where it, as much as it points to the fact that this might be the cleanup that Indian politics need, but at the same time, this might also be a political weapon where we are making a constitutional change which might be directed towards opposition. That is why there are direct political concerns as well, because this bill, if it becomes an act, might be used to politically target opposition leaders and topple them off the position that they are present, and there might be misuse of investigative agencies also to make arbitrary arrests so that the removal can take place. So this might give overarching powers in terms of a political weapon which is being introduced as a constitutional amendment bill. A recent example that you can take, if we talk about V. Senthan Balaji, the 2023 arrest which happened in Tamil Nadu, it triggered legal and political controversy in the terms that he should resign, he should be removed, and if this bill is to become an act, then this is something that can be carried out to target opposition, and that is the main worrisome point related to it. This is leading to a wider debate as well, where we are focusing on balancing constitutional morality versus political misuse. You can give your thoughts on this in the comment section, and it also raises a question: if we are at the very stage of arrest and detention, putting a person out of his office, putting the person in a different, then we are not giving him the benefit of doubt, or we are not even assuming that he might be innocent. We are assuming that he is guilty and that is why he needs to be removed. So in such a situation, the removal on the arrest itself undermines the whole presumption of innocence, which also needs to be given a thought. Now we will move to something very much important related to this particular bill, so as to make you understand that why this bill or why this thought by public, by the government is of such importance. At present, what we see in form of criminalization of politics. So if we look at the data, we will find that since 2009 to 2024 Lok Sabha election, there has been an increasing trend where at present we are seeing 46% of our MPs who are coming from a background where they have criminal charges against them. In the very same, if you look at the candidates who appeared for 20%, highest number that we have seen are coming from a background where they have criminal charges against them. Other than that, if you look at this particular data, this will show you the percentage of candidates with serious criminal charges and criminal charges background, and here also you will find that it was in 2024 that highest 14% of candidates had declared serious criminal cases against them, including murder, attempt to murder, crimes against women, etc. So this is what our lawmakers are coming from. And that is why this addressal becomes very important at this very time, because this will reinforce the public's trust in governance. This will send a strong message that there is no tolerance by the public for tainted ministers, and there will be a proper legal framework which will be facilitating this decriminalization that we want to see in politics. So when we are talking about the need of such a bill, it is also highlighted by the judicial delays and electoral incentives. As I had already mentioned, that a candidate with criminal record is 3x likely to win as compared with a clean record. Furthermore, we see judicial delays. As of now, almost 4,500 plus cases are pending if we are talking about lawmakers. And that is why an important step in this direction has been rightly taken, and this can be understood through comparative global practices that are present all across the world. Even though if we talk about UK, Australia, there is no act as such, but there is a ministerial code, and if resignation takes place, it is through convention, not by law. If we talk about France, courts have the power that the convicted individual will be deprived of the political rights. Germany also has an automatic disqualification if there is a sentence of equal to or more than 1 year imprisonment. But all of in this context, if you see the bill presented in India, it is more stringent, properly legal and automatic process as compared to the conventions that we are seeing abroad. This seems like a good step, but it needs to be balanced with constitutional morality. What are your thoughts on this? You can put it down in the comment section. That was all from my side. Thank you so much.